Australian Migration Chronicles, Stranger Than Knife Series, Video 2, The Case of Legitimate Expectation. Although this is the second video of the Stranger Than Knife series of my Australian Migration Chronicles, it is in fact the first of an estimated total of 10 videos in which I want to share my previous experience as a registered migration agent, because the first video was an introduction about the series. As clearly stated in the introduction, despite the fact that I had been a registered migration agent for over 20 years, I'm no longer registered for health reasons. Consequently, I'm quite mindful about what I'm going to say in this series, because it is not my intention to get myself into troubles. I would like to take this opportunity to reiterate that viewers should not accept what is being said by me in this series as migration advice. The details provided are meant as facts I came across in my career as a registered migration agent. They are details that I recall as my personal experience. Viewers needing professional advice should always seek them from a registered migration agent. Although most of my proposed 10 videos in this series will be based on cases I handled before, this first video was not one of them. I came across the details of this case when I was researching on another case in connection with the balance of family test. The case I'm going to talk about is one which was reported in the Migration Review Tribunal. Strictly speaking, the case is in the public domain. However, following the philosophy I'm going to adopt as detailed in the introduction video, I shall hide the true identity of the parties concerned by not mentioning names. In 1998, the applicant married her husband, who had 2 children from his first marriage. The case was basically one in connection with balance of family tests, and the vital point hinged on whether the 2 children from the husband should be counted in the balance of family test. Evidence was produced that the legal custody of the 2 children was removed from the husband. The family went to the Perth office of the department and, according to the applicant, was given verbal advice by an officer who, based on the instruction given on the department's website at that time, that children are not counted in the balance of family test if they are removed from their parents' legal custody, the applicant was encouraged to apply. As a matter of fact, even as late as September 2000, at the time the MRT hearing, the department's website was still showing that children are not counted in the balance of family test if they are removed from the parents' legal custody. Subsequent to the application being lodged, the visa applicant received ongoing correspondence during 1999 relating to the processing of the application, including advice about a new visa class, capping of the 1998-1999 visa intake, the need for health examinations, and assurance support forms. Medical examinations were undertaken and the assurance support form completed and returned. Because of the ongoing processing, the applicant and the family were under the impression that substantive criteria of the subclass, including the balance of family test, had been met. In September 2000, the applicant and her family were surprised and bitterly disappointed to receive a letter confirming that her application had been rejected. The case became the subject of an MRT hearing in which the decision was affirmed. The case was argued by the registered migration agent on both legal and compassionate grounds. The agent argued that advice given by a departmental officer prompted the applicant to lodge the application. He went on to say that the ongoing formalities, including updating of details regarding change of visa subclass, capping of yearly intake, completion of medical examinations, and successful lodgement of assurance of support were procedural affirmation resulting in legitimate expectation. Unfortunately, the tribunal took a different view. Number 1. To the claim that the application was lodged on the suggestion of the departmental officer, the tribunal noted that there were no departmental records to confirm this, and it was unable to make any definitive findings in respect of this issue. Number 2. To the instruction of the department's website that children are not counted in the balance of family test if they are removed from the parent's legal custody, the tribunal gave legal distinctions between exclusive custody and shared custody, concluding that legal custody referred to shared custody only and not exclusive custody. Number 3. To the procedural affirmation argument, the tribunal considered that legitimate expectation cannot alter, nor can the balance of family test be taken to have been satisfied on the basis of what was not the correct interpretation of the Act and regulations. Normally at this point, one would finish off the discussion by looking at the moral of the case. However, any summary or conclusion based on the facts of the case may involve analysis on interpretation of the Migration Act and regulations. In an effort to steer away from traces of any suggestion or attempt to provide migration advice and consultation, I am refraining myself from comments and observations regarding the moral of the case by leaving it to the intelligent faculties of the viewers. My next video is a case on spouse visa. I was greatly amazed by the techniques and the lengths the case officer took in the assessment process. I'm sure the details will be of interest to anyone who is involved in spouse visas. Now, this concludes the contents of this video. If you like this video, please give it a thumbs up and subscribe for more. You're welcome to ask questions and provide constructive comments. Meanwhile, thank you for watching and cheerio.